Welcome to Housing After 60. I am Charles Odell. On this site, we analyze the math and the reality of senior housing to find your best options. Let's get started.
Welcome to another deep dive from Housing After 60. Today, we are looking at how to safely manage contractors and protect your home equity. Based on our latest research at housingafter60.com, we're going to show you how to build a fortress around your most valuable asset. So let's get right into it. You're finally ready to pull the trigger on that dream kitchen, right? Or maybe it's that incredible bathroom you've been planning for years. It's exciting, but we have to ask the tough question. Is that dream project actually a huge financial risk? Because without the right strategy, that beautiful vision can turn into a financial nightmare that just eats away at the equity you've worked so hard to build. And that really gets to the heart of what we call the contractor dispute trap. And let's be really clear here. A dispute with a contractor isn't just annoying or frustrating. It is a direct threat to your home equity, which, for so many of us, is the bedrock of our retirement savings. The stakes could not be higher. So let's put a number on it. Is there a magic number where everything changes? Well, our research points to a very specific figure, and you see it right there, $15,000. You need to burn this number into your brain. It's the financial line in the sand where it even starts to make sense to get a lawyer involved. Below that, you're in a really tough position. And this quote, which comes directly from our research on housingafter60.com, tells you exactly why that number is so important. Do not call a lawyer until the damages exceed $15,000. Otherwise, the legal fees will cannibalize your recovery. I mean, think about it. You're paying a lawyer $400, maybe $500 an hour. You could go to court over $10,000, win, and still end up with a $12,000 legal bill. You've technically won, but you've actually lost money. That's why preventing the problem in the first place is absolutely everything. And when we dig into these nightmare situations, we find they almost always come from the same two mistakes. First, a vague contract that leaves way too much room for interpretation. And second, premature payments. Handing over big chunks of cash before the work is actually done and verified. And today's guide is all about making sure you never make either of those mistakes. Which brings us to your absolute first line of defense, the contract itself. And you have to stop thinking of this as just some piece of paper you have to sign. No, this is your fortress. It's the wall you build around your home equity before a single nail is hammered. So, a truly protective contract, an ironclad one, really stands on 4 pillars. The first one is a ridiculously detailed scope of work. You can't just write new faucet. You have to write Kohler Model K596 vibrant stainless steel, SKU number XYZ. Every single material, down to the brand of paint, needs that level of detail. Pillar 2 is the payment schedule. Payments get released only when specific, verifiable milestones are hit, not just because it's the first of the month. Pillar 3, a firm timeline with a hard start date and a hard stop date. And number 4, and this is a big one, you have to personally go to your state's database online and verify their license and insurance are active before you sign a thing. Now, let's zoom in on that payment schedule because this is where homeowners lose all their power. We call this the 10-30-30-30 rule. It's simple, but it's incredibly effective. You pay only 10% down, period. Then you release the next 30% after the rough-in plumbing and electrical passes inspection. The next 30% comes after the drywall is up. And that final 30%, that's your leverage, that's your power. That does not get paid until you've done the final walkthrough and every single little item on your punch list is fixed to perfection. Okay, now for a huge red flag. If any contractor ever says something like, hey, we can save some money and time if we just skip the permit, you run. Don't walk, run the other way. As we lay out on housingafter60.com, this has nothing to do with saving you money. It's about them shifting 100% of the legal liability onto your shoulders. Unpermitted work is illegal. It can completely void your homeowner's insurance, and it strips you of pretty much any legal recourse if things go wrong. It's just never, ever worth the risk. All right, so you've got your ironclad contract. The work starts. You might think your job is done, right? Not even close. This next part is all about active vigilance. You can't just sign the check and disappear. You have to be a meticulous overseer of your own project. And there's a brutally honest quote from our research that every single homeowner needs to hear. If you end up in front of a judge, the person with the most paper wins. It really is that simple. How you feel, how frustrated you are, it doesn't matter in court. What matters is the evidence, the documentation. You have to build your case from day one, just in case. So what does that paper trail actually look like? Well, here's your toolkit. First, stop having important conversations on the phone. From now on, it's text and email only. You need that written record. Second, you are now the project photographer. Take hundreds of pictures, especially the stuff that's about to be covered by drywall, like the plumbing and wiring. And third, start what we call a failure folder. Every single receipt, every change order, every piece of paper goes in there. You're not just renovating a house, you are creating a NASA-level flight log for this project. And just remember this mantra: cash is the only leash you have. The project isn't over just because the contractor packs up their tools. That's why you have to hold back a final 10%. It's a practice called retainage for a full 30 days after they say the job is done. Why? Because when a slow leak appears in week 2, that final payment is the only thing guaranteeing they'll come back immediately to fix it. But what if you do everything right and things still go sideways? Well, the first thing is, don't panic. You need a calm, logical process. We call it the dispute escalation ladder. It's your step-by-step playbook to handle problems without losing your cool or your shirt. The ladder has 4 rungs, and you always start at the bottom. Rung 1, direct communication. You calmly go to the contractor with the contract in your hand and point to the specific clause that's being violated. No emotion, just facts. If that doesn't work, you climb to rung 2, a formal, written notice to cure. You send it by certified mail, and it gives them 10 days to fix the problem. Rung 3, now it's serious, you file a complaint with the state licensing board. That threatens their ability to work, so it gets their attention fast. And the very last resort, the top of the ladder, is small claims court. And this chart right here is exactly why you have to follow that ladder step by step. Just look at the costs. Sending that notice to cure yourself costs you what, maybe $15 for the certified mail? If you skip that and go straight to a lawyer to write a letter, that's $500. Easy. And if you jump straight to a full-blown lawsuit, you're talking $15,000, $20,000, even $50,000. The process is there to save you a fortune. If you want the full technical breakdown of these costs, check out the post on housingafter60.com. Okay, finally, let's talk about the long game. Because a contractor dispute isn't just about the headache you're dealing with today. These things can cast a very long shadow on your finances, and even on the financial legacy you want to leave for your family. One of the most common weapons a shady contractor has is something called a mechanic's lien. What is that? Well, it's a legal claim they can slap on your property's title saying they haven't been paid. This puts a cloud on your title, which basically freezes you. You can't sell your house, you can't refinance your mortgage until that lien is taken care of. It can literally paralyze your finances. So, what's your shield against this powerful weapon? It's a simple piece of paper with a very long name, the final unconditional lien waiver. And the rule here is absolute. You do not, under any circumstances, hand over that final payment check until they have handed you this signed waiver. It's their legal statement saying, I've been paid in full and I give up all rights to ever file a lien on this property. It's your proof that the deal's done. And one last but really important point about your taxes. Let's say you lose $10,000 to a bad contractor. Unfortunately, the IRS sees that as a personal loss. You can't deduct it. It's just gone. However, and this is a big however, the money you then have to spend with a good contractor to fix the bad work, that money can be added to your home's cost basis. And a higher cost basis means you pay less in capital gains tax when you eventually sell the house. So save every single receipt from the repair work. So, we'll leave you with this final thought. A $10,000 dispute today might seem awful, but manageable. But is it worth letting that dispute fester? Because with interest and legal fees, it can easily blow up into a $25,000 nightmare lien on your title, a nightmare that your kids will have to inherit and untangle. Protecting your equity now is really about protecting your family's legacy tomorrow. Thanks for watching. For more guides and the full article on this topic, head over to housingafter60.com. Don't forget to check the links in the description below.
Your peace and enjoyment in retirement depends on the right housing strategy. Visit housingafter60.com for our full analysis and cost transparency guides. I will see you in the next video.